Good morning, ladies and gentlemen. I, Dr. Shashwat Bajpayee, on behalf of the entire DAW committee, welcome you all to the week of the year, the second Delhi arbitration weekend. The only thing sweeter than union is reunion. It's a pleasure and honor to have been given the task of comparing the day one sessions. And before I straight dive into it, I just want to ask everyone a question. Most of us have seen the movie based on India's 1983 World Cup exploits, the Ranveer Singh starrer, the movie 83. There's a surreal moment in that movie where Kapil Dev, who's portrayed by Ranveer Singh in the movie, who's not very familiar with the English vernacular at that point of time, urges his team members to strive for repeated success and expresses his sentiments in his usual uncanny manner. And we know it as the famous Kapil Dev World Cup line where he says, "Taste success once, tongue once more." This is exactly what we're here to do today. Juxtaposing that today, we're all gathered here for the second edition of DAW after the grand success of opening for the first one the preceding year, striving to emulate and repeat the success more and more. With that, we open the curtains to the first day of the technical sessions of DAW 2024 with a huge round of applause, please. The first technical session topic of the day is Riddles of Righteousness in Arbitration, an Ethical Dilemma. Just to give a brief introduction of the topic, the international arbitration is seen by some as an ethical no man's land due to the absence of a uniform code governing the arbitrators and council's ethical responsibilities. The session seeks to address this ethical gray area, which is further obscured by the fact that international arbitration involves parties, councils, and arbitrators from different jurisdictions and cultures, which may have divergent views on what is and isn't right or just. The panelists will also offer a comparative perspective by analyzing the Indian, English, and Singapore positions on arbitrator and council ethics in arbitration, while further discussing the role that the arbitral institutions play in developing this area of law. We have an eminent panel today for the discussion, and it is my absolute pleasure to first welcome the chair of the session, Honorable Justice UU Lalit, former Chief Justice of India Supreme Court. Justice Lalit was appointed Judge of the Supreme Court of India in 2014 and became the 49th Chief Justice of India on 27 August 2022. He holds the unique distinction in the distinguished view to have been directly elevated to the Supreme Court from the bar. Prior to his elevation, Justice Lalit practiced in the High Court of Bombay and Delhi and was designated as senior advocate by the Supreme Court in 2004. Notably, Justice Lalit appeared as amicus curiae in several matters and was appointed Special Public Prosecutor for CBI to conduct trial in all the 2G matters under the orders of the Supreme Court. He was also a member of the Supreme Court of India Legal Services Committee for 2 terms. He is currently a distinguished visiting professor at NUJS Kolkata and the Indian Institute of Technology, Bombay. We are thankful to him for gracing the dais. We're also joined on the panel by Shania Ilyas, the Deputy Director for ICC India. Shania is a distinguished arbitration expert with a practice area focusing on advisory, arbitration, commercial litigation, and joined ICC India as the Deputy Director for Arbitration and Alternative Dispute Resolution in June 2023. Prior to joining ICC, Shania worked in the dispute resolution practice of a leading law firm, DSK Legal, for the infrastructure and project-related disputes and advised on risk mitigation strategies. We also have on the dais Mr. Prashanto Chandra Sen, Senior Advocate. Mr. Sen is a senior advocate practicing in Delhi and various high courts of India. He has developed his practice in both commercial as well as public law. His arbitration practice spans appearances in ad hoc and institutional arbitrations. He has been ranked as Tier 1 in the first ever survey of senior advocates by Legal 500 Asia Pacific for the year 2022-23. He accepts appointments as counsel and arbitrator and is currently a core committee member of the ICC India Arbitration Group. We are also joined by Mr. Kelvin Poon, SC Deputy Managing Partner, Head International Arbitration, Rajah and Tann, Singapore LLP. Kelvin has extensive experience as counsel in a broad range of construction and commercial disputes in numerous arbitration across the Asia-Pacific region. Kelvin has also regularly appeared in the Singapore courts and sits as an arbitrator. He is fellow of the Chartered Institute of Arbitrators and is a member of the core committee and the Selection Committee of the ICC Singapore Arbitration Group, as well as a member of the ICC Commission for Arbitration and ADR. Kelvin was also a member of the International Bar Association's Working Group on Harmonizing Arbitration Laws in the Asia-Pacific region. We lastly also joined on the panel Ms. Parnika Chaturvedi, partner, Quinn Emanuel. Parnika is a partner in Quinn Emanuel's Abu Dhabi office. She specializes in international commercial arbitration and common law litigation. Parnika has extensive experience conducting arbitrations under all major arbitral institutions and ad hoc tribunals, and works with regional experts on disputes before the UAE court. She has also substantial experience before the Dubai International Financial Center courts, the Abu Dhabi Global Market courts, and the courts of England and Wales. I welcome all the panelists, and may we have a huge round of applause for the chair and the panelists. May I request Justice Lalit to please felicitate the speakers. Without further ado, I hand it over to Justice Lalit to please take it forward.
Good morning, everyone, and welcome to this session. As the introduction began by saying that this is the second version of the conference that we successfully held on the last occasion, so therefore now it's the continuation and perhaps, as he rightly said, reunion. But right in the beginning or at the outset, I must say I apologize for the delay which got occasioned as a result of my failure to be here on time. I'm so sorry, my apologies. You have heard the introduction of the distinguished panel which is present today. We have persons coming from various jurisdictions who have immense experience behind them. And what a wonderful panel to have a discussion on what is called riddles of righteousness in arbitration, an ethical dilemma. You know, we in Supreme Court, as judges, sit under the emblem of Supreme Court, which says, Yato dharmas tato jayaha. You know, in Sanskrit it means whatever is right or the path of righteousness must always succeed. And this was an Ashirwad given by Gandhari to her son Duryodhan just before the Mahabharat war. When the son went up to his mother to seek the blessings, she didn't say that you shall succeed in the war. She said, if you are right, you shall succeed. So the path of righteousness is something which is part of Indian ethos. It is precisely for this reason that Mahatma Gandhi called off Quit India movement. Why? Because there were violent demonstrations at certain places in the country. To him, the means were as good or as equally important as the end in itself. And therefore, path of righteousness. Now coming back to the arbitration as a subject, what we normally consider independence, impartiality on part of the arbitrators is the key to success of the entire arbitral process. There's one more I, apart from independence and impartiality, that is integrity of the process. And this integrity of the process is something which, combined with independence and impartiality will bring in what is called the righteousness or the fairness or the good morale which could be displayed by the entire process. Now, I asked the organizers that why have they chosen this particular subject? And the answer which I got was, there's a recent judgment by English Commercial Court in the case of Nigeria versus PAID. And that judgment has now thrown up various issues, various ideas, which could be now the game changer in the process of arbitration hereafter. And so therefore, taking that judgment as the central theme of the matter, let us begin the discussion. We have such wonderful speakers today. So I shall call upon, I'll go purely by the sequence in which the distinguished speakers are sitting next to me. And I'll call upon Parnika, who is sitting next to me. She has good number of years of experience. So let us begin and let's request Parnika to first of all place what that judgment means and what has that judgment laid down and what are the problem areas or what are the sort of, good ideas which emerge from that particular judgment. So may I request Ms. Parnika Chaturvedi to open the innings today. Yes.
Thank you, Justice Lalit. Good morning, everyone. I think Justice Lalit has given a very good description of what the panel today will try and explore is terms of integrity of the process in arbitration. And the reason why we picked this judgment is I'm sure a lot of you would have heard about it, and it's described quite regularly as an explosive judgment because it set aside a $6 billion arbitration award against a state. Before I go into details of what the judgment actually said and the issues it tries to tackle or sort of deals with, I'm not sure it tackles everything. It, I think, throws up more things than it can give answers for at this point. For everyone, so in 2010, Nigeria and PNID entered into a contract, which was a gas supply and processing agreement. Now, under that agreement, Nigeria was to provide certain quantities of wet gas to a gas processing facility, which was to be built by PNID. And then that gas was to be converted to be used for electricity generation in Nigeria, with the remainder of it to be sold either domestically or exported by PNID. It was a 20-year contract. About 3 years into the contract, approximately about 2012, 2013, PNID commenced arbitration against Nigeria. And the assertion was repudiatory breach of contract by Nigeria. They said that Nigeria was failing to supply the gas that it had promised it would. And on the other hand, Nigeria said, you have not built the facility. How do you expect us to supply the gas? The case went on for a number of years. There were substantial delays. Between 2015 and 2017, there were 3 awards that were rendered by the tribunal. It was a 3-member tribunal. And there were awards on jurisdiction, where the tribunal said, we have jurisdiction. There was an award on liability, where the tribunal said Nigeria is liable for repudiatory breach. And there was an award on quantum. The award on quantum was for about $6 billion, plus interest. By the time it reached 2019, when Nigeria applied to set aside the award in the English High Court, this was a London-seated arbitration, the award value had approximately reached $11 billion, which was substantial for the Nigerian budget. And the court started hearing the matter at that point in 2019. It was a very interesting point because Nigeria had to get special permission to be able to challenge the award. It was outside the limit, and getting an extension to this extent was pretty unheard of from the English courts. it was a pretty extensive trial to set aside. And some of the grounds that were raised at the set aside, the main ground that was raised was under public policy. 8-week trial, extensive cross-examination of fact witnesses, expert witnesses cross-examined, and the judgment came out. Now, before I tell you what the judge said, public policy was quite interesting because you see it come up a lot whenever there are challenges to arbitral awards. It's one of those kitchen sink approaches which is used by parties on a very regular basis. You'll find it in most jurisdictions as a ground of set-aside. Anyone who is a party to the New York Convention would have it. UNCITRAL model law has it. The ambits of that public policy are sort of undefined. It's called an unruly horse sort of described as an unruly horse quite regularly. But one thing which is pretty consistent across jurisdictions is corruption, fraud do fall within that ambit of public policy. I'm personally not aware of a jurisdiction which says public policy will not include allegations of corruption and fraud. So the judgment came out. It was one of those judgments which just pretty much shocked the community for different reasons. Some said it was expected, some were very surprised by it, and it raised a lot of questions. So what did the judge what happened during the hearing that the judge set aside that award? An award against a state for an arbitration that had gone on for nearly 5 or 6 years. The judge said evidence was put before him which could not have been known by Nigeria that showed that PNID had knowingly relied on evidence in the arbitration and concealed the fact that there was bribery to an Nigerian official. PNID continued to pay bribes to the official throughout the arbitration. The witness evidence put forth by PNID was not true. There were bits of the witness evidence where the witness did not disclose facts which should have been disclosed to the tribunal. And the counsel and PNID, the counsel for PNID and PNID knowingly made use of privileged documents which, once it had come into their possession, should have been notified to Nigeria. And the judge said, if the tribunal knew about this at the time of the arbitration, if this had become known to the tribunal, the arbitration would have resulted in a very different award. Now, where does that leave us? Because what are the questions that have come out of this? Let's go through the questions. We start with the one big question, disclosure, which my co-panel member over there would deal with. We then talk about what is the role of counsel in these arbitrations. We also need to think about what is the role of arbitrators and what do you do when there are allegations of corruption and fraud or potential allegations of corruption and fraud, as in this case, because there were no allegations of corruption and fraud while the arbitration was going on. One finds that increasingly, as states enter into commercial contracts, especially states who rank pretty low in the what we call the transparency index or the corruption index, you will find allegations of corruption and fraud being made regularly in arbitrations, whether it's bribery, whether it's forgery of documents, or any of those sort of wide spectrum. And historically, arbitrators have been quite reluctant to deal with these allegations. It's a private process which is by agreement of the parties, and the view has been that arbitrators cannot and should not touch this, and that's been the traditional view. I see that changing a lot, and the reason I see it changing is because the courts are also dealing with it differently. You find that when in different, let me start with, in different jurisdictions, it's dealt with differently. Because what it comes from is also the Arbitration Act, the kind of powers that an arbitrator has under it, whether it can go to court for certain kind of relief, what are the reliefs that can be granted by the court, and also the parallel criminal procedures that can be instigated. It also comes from how does the law of the jurisdiction, which is the seat of arbitration, and the law of the contract itself, what's the interplay between them? Because when you have these allegations of corruption and fraud, a very important question is there before the tribunal, which is this contract void? Is it voidable? Or can you actually have a decision where you can make, even though you find that there has been corruption or bribery in the contract, you can still go ahead, hear the dispute, because there might be claims of unjust enrichment. And I think it's a very tricky area in arbitration where different arbitrators tend to deal with it differently. Going back to this case in particular, what the court said was that the tribunal should have looked more closely at the evidence and raised questions because there were obvious evidence before the tribunal which should have created doubt in their mind. I don't completely agree with that, I have to say. The arbitration went on for 5 or 6 years. Evidence is presented by the parties. Now, if there's a 20-page contract, as was in this case, put before the tribunal, and the parties both said, this is our contract, I'm not sure as a tribunal member, you turn around and say, we don't agree, you should have had a much more detailed contract because it was for a 20-year period. Is that really the role of the arbitrator? Isn't that the role of the parties or the council? And to what extent should arbitrators interfere? If a party has chosen, and I think this was one of the arguments that PNID made, it said if Nigeria chose counsel which could not effectively represent them, is it our fault? And or the arbitrator's fault for that matter. As a party, you're responsible for choosing your counsel. And I think that's a question which still, the judgment says one way, it's more obiter remarks than anything. It's not the ratio of the case, but it is something which creates questions in the mind when you're sitting as a tribunal. The third is in relation to arbitrators generally. Now, whilst the arbitrators have a duty, generally, most arbitration rules, if you're going under one of the popular arbitration rules, such as ICC, and if you have, there will be a duty on the arbitrator to ensure they render an award which is enforceable. To what extent can you actually push that duty? Fair hearing? I've heard evidence and I've looked at whatever evidence you've given me, I've had a hearing, and this has been going on for 5 years. How can one party turn around and say, I've not had a fair hearing? Which was a consideration here, because the court said, and I'm paraphrasing, it said that Nigeria had not been able to present its case properly. But where do you draw the line in something like that? To what extent should arbitrators interfere? Should arbitrators start presenting the party's case if they think it's not being presented properly? I think that's a very dangerous slope to be going down, because the whole point of these procedures is that you have a panel who act as judges and listen to the party's cases and render a decision on it. The role of those arbitrators, yes, they do ask questions if there's something before them which raises doubts, but it's not to start investigating on behalf of the parties or start presenting a case on behalf of the parties just because they're not being represented properly. I'm going to just, hand over the mic for disclosure and role of counsel, and then I think we'll come back to generally talking about what can be the takeaways from this case and what are the issues we all should be thinking about.
Thanks, Parnika. As the speaker rightly said, 3 awards. And at a stage where the challenge procedure now finally lands up in commercial court, challenge to the award, it is at that juncture that this particular plea gets entertained and gets accepted. There are certain observations in the judgment which indicate that the officials who were responsible for entering into contract on behalf of Nigeria had actually compromised their position. There were certain bribes, there were certain amounts which had exchanged, suggesting that perhaps the contract was lopsided and was made so deliberately. Then the counsel concerned was also somebody who had compromised his position, who had appeared at the stage when the arbitral proceedings were going on. Mind you, the arbitral proceedings, the arbitration was presided over by somebody who was formerly judge of the appeal court. So a very distinguished panel. And as Parnika rightly put it, some of these arguments, some of these submissions were never advanced before the arbitral tribunal. Nonetheless, the court has gone about and set aside the arbitral award on the ground that the process was completely compromised. Number one, at the stage when the contract was entered into, that is even anterior to the stage where the contract actually saw the light of the day. And then subsequently, when the counsel in question had also compromised his position. So therefore, this has thrown, that's why in the opening I said, this has thrown too many questions now. So therefore, whether the court in question, while dealing with a challenge to the award, can go into questions as to in what conditions the contract was entered into. There are a number of issues which actually come up. So therefore, now we have, the next speaker is Kelvin Poon, who is the senior counsel. He has tremendous amount of experience of having worked in international arbitrations, and his base is in Singapore. So therefore, he will be now presenting a view from a diverse or a different perspective. So let's listen to Mr. Kelvin Poon on this subject, including the drift of the discussion up till now, and he can also respond to that, and what exactly would be the role of a counsel, and to what extent the arbitral proceedings can be subject to this kind of challenge in a court of law. Yes.
Thank you, sir. It's an honor and a privilege to be here. And the topic that is being discussed is truly a vexed one and a difficult one. We were having a chat at the speaker's lounge before the session began, and one of our colleagues, a speaker later, raised the point and said, look, Justice knows from his commercial court indeed asked very difficult questions as to how could this have happened. But the truth is, what could the tribunal really have done in a case like this? Because the tribunal is really part of a process that decides the disputes that are put before it, and they can only work with the material that it's got. So I think we can all appreciate that the tribunal has a duty to ensure that its procedures are not being abused to facilitate fraud or corruption. But the judgment doesn't really quite explain what is it that they felt the tribunal could have done better. And I think that's a thought that continues to haunt us because of the private and in a sense, the adversarial nature of the arbitral process. So in Singapore, we have not had a case as explosive as Nigeria. Yeah, we haven't. But I have to say the question has been hinted at a number of times. So maybe what I will do is just to sketch, as outline, what is the approach that the Singapore courts have taken on the duty of the tribunal to investigate fraud and corruption. And there are two key decisions that have discussed this issue. One is China Machine, New Corp, and Jaguar. There's a decision of the Singapore High Court by Justice Kanan Ramesh. And the second is Laos Holding against the government of Laos, PDR, a decision of the Singapore International Commercial Court. And I can perhaps sum up the approach in four broad principles. The first is tribunals have a duty to investigate if there's fraud or corruption involved in relation to the contracts, but the issues must engage the dispute that's been brought before the tribunal. And just on this first point, it is quite important that this limitation is there. That the tribunal is not an international criminal court. That the tribunal is there to resolve complex legal disputes between the commercial parties. So in a real sense, if the tribunal strays into a discussion or investigation on serious matters of fraud, which do not impinge on the contract itself, then there could be a real argument that the tribunal has strayed beyond its mandate. So in Singapore, at least in the two decisions, the courts have been very clear that the allegations of fraud and corruption must touch on the underlying issues concerning the dispute. So that's the first point. So if the duty is engaged, then the next question that comes out is, when should a tribunal get into it and to investigate? And again, there is a concern here. We hear in every arbitration conference the concern that arbitrations are getting very expensive. So clients and users will say, I want you to only investigate matters which affect us as the users of the arbitration and who are paying you for the job. So that the tribunal cannot go on a broad-ranging investigation on its own. And so in Singapore, what the courts have held is that the tribunal should step in only if it becomes aware of circumstances that could give rise to a suspicion that fraud or corruption might be involved. Again, I think it's sensible. It sort of curtails the scope of the work that a tribunal needs to do, yet striking that right balance that we all need. So that's the second principle from the two cases. The third is this. The third is that what is the rationale for the tribunal to do this? So the Singapore courts have explained it in this way. They say that the tribunal has to do this because it has a duty to prevent the arbitral process from being abused to facilitate fraud or corruption. And this is quite an important nuance to the discussion and debate. I think earlier Parnika mentioned that sometimes a question may arise as to whether the fraud in question voids the contract ab initio, or is it purely voidable? Because if it is void ab initio, then clearly it's engaged. Regardless of the position of the parties, the tribunal can get into it and make a ruling on what its impact is on the contract. But if it is voidable, then maybe not. Because one party may say, regardless of the fraud, I'm quite happy to leave the contract as it is. So in that sense, should the tribunal then say, then maybe I shouldn't get into the weeds of uncovering the fraud? But the Singapore court seems to have gotten past that issue by addressing the concern differently. If the concern is to protect the arbitral process, then it doesn't matter whether the fraud in question makes the contract void or voidable. Because the concern is not with the merits of the commercial arrangement between the parties, but with a concern to ensure whatever award that's issued does not promote fraud. So I think that neatly, I think, bypasses, I think, some of the concerns and issues that have been raised, that Parnika has raised. And the last principle that the two cases have discussed is this question of whether evidence of the fraud can be excluded by agreement. You may ask, that sounds quite pretty much self-evident. But what happened in Laos is quite interesting. So there was a BIT, investment treaty arbitration, has commenced. And halfway through the proceedings, parties reached a settlement of sorts where they agreed to suspend the arbitration pending certain actions being done by the Lao government. And the agreement was, if there was a breach, then the arbitrations would be revived. But there's a line in the settlement agreement that says, you shall not raise any new claims or allegations, words to that effect. So as things happened, the Lao government was found by the tribunals to have breached the settlement. That revived the arbitrations. The Lao government then put forward evidence to suggest that the underlying commercial contracts were tainted with some fraud or corruption. And so the argument was made by the claimants, hang on, you can't rely on this. Because of our settlement deed, you can't make a new claim now that the arbitration has been revived. So that the evidence should be excluded. The court was quite clear when you're faced with this. So eventually the tribunal ruled in favor of the Lao government. It dismissed the claims, and that led the claimant to challenge the award in the Singapore court. And on the specific point of that finding, the Singapore court said, look, the tribunal strayed beyond its mandate because of what was said in the settlement agreement, that you should exclude fresh claims. The court held that on a proper interpretation of the clause, it did not have such an effect, because it's not a new claim. It's a defense to an existing claim relating to actions on the underlying contract. But the court went further and said, look, even if it was caught by the agreement, that the court cannot allow parties to agree to exclude such evidence that goes to the heart of the underlying dispute in a particular context where fraud and corruption is involved. So I think the Singapore court has made it very clear that it is not prepared to allow its processes to be used to facilitate corruption. So maybe now I'll turn very briefly to the difficult question of what role counsel should play. And in fact, it's all very neat. That last night when I was in the car, this topic came up as well. It seems that we have wisdom everywhere we go in India, in Delhi in particular. And the question was, look, we are lawyers for our clients. We are here to advance the client's interests. But I think one of the reflections that came out of the conversation was this. We lawyers are in a bit of a unique position. Because when we advise the clients to do what is right, even if that's not what the client wants, that tends very much to be a decision and an action that ultimately benefits the client. So, to serve your question, then it means the simple point is we lawyers should do our jobs properly and to make sure that we only advance claims that are right and correct, and we do not facilitate these transactions. But we know, all of us, most of us here know that there will invariably be one or two sheep that don't march to the same tune as the rest. And what do we do? And unfortunately, in a system as global as arbitration, it is very, very difficult to lay down any black letter rules that can police this. I think there are various mechanisms that have been proposed in the past. Institutions like Chartered Institution, for example, can we police discipline through the institutions? I think that there is a room for that. There's a room for education and a room for spreading the word on what the ethical obligations are for counsel. But in the end, it's really about us as a community policing ourselves. Because we play an important function in facilitating trade across the globe that has a big part in in raising lives, commercials, standards of living across the globe. And I think it is our jobs as council, if I may say so respectfully and humbly, to preserve that process. So very vital in these troubled times.
Thank you, Mr. Poon. What a brilliant way to present the view. But at the same time, there are certain observations in the judgment which show that it was only through the disclosures which were demanded or requested that it came out that PNID had actually made certain payments to the counsel who was engaged to appear on behalf of Nigeria. So it's not just the role as a counsel representing your client. There's something greater than that, that you're compromising your position. So therefore, that's why one of the shades or one of the areas on the basis of which the judgment is founded appears to be the fact that the counsel deliberately underplayed, deliberately did not argue, deliberately did not present a particular view which ought to have been presented on behalf of Nigeria. So that's why this judgment actually throws up many issues. We have up till now seen 2 reflections on this vexed topic. Now I shall request Mr. Prashanto Chandra Sen to just move along with the drift of the discussion, at the same time present to us what is the Indian perspective apropos this particular topic which is presently engaging our attention. So over to Mr. Prashanto Chandra Sen.
Thank you very much, Chairperson. First of all, I'd like to apologize. I had come with a prepared speech, which was a written speech, which was there. And then to my horror, I found that we have to sit here also, which makes it even more difficult to refer to your prepared speech. So because I was even more backward than a technological slide presentation.
If I may intervene at this stage, counsel are always standing counsel. So therefore, they think on their feet.
Yes. So I can be excused for dumb points being raised sitting. But having said that, when I first saw the topic, I was a bit riddled myself with the topic itself. And I spoke to Tejus Chauhan and asked him what this was all about. And when he mentioned the fact that it was based on this case, the first riddle was solved. But then there were other aspects which arose. What was the riddle, even if we look at the fraud aspect which is there? Fraud is one thing which is black and white. I mean, there is in international arbitration debates about diverse practices which are there, how to merge them, etc. But I think there is no doubt about one thing, as far as when fraud vitiates the arbitral process, and that's the case in India as well as Singapore, as well as anywhere in the world, the award has to be set aside. So there was no riddle there at all, which seemed to me at first blush. But as one read deeper into the judgment, there were a few points which came up, which I would like to highlight. Now, the first thing I'd like to begin with is by saying that I was a bit delighted to see that the arbitration went on for 5 years. There's often a lot of criticism. We ourselves criticize our own arbitrations many times in India, going on for a long time. And I'll have something to say about that. But at least I was happy to see that this one went on for 5 years. It was a very celebrated arbitration. But having said that, the first point, 3 important points which struck out, apart from what the court said. One, what Justice Lalit just raised, disclosure of documents. The fact that it was rigorous in its disclosure requirements made a difference in being able to discover the fraud. The second thing which ails us also in India, and it's something which I'm going to speak about a little bit, was the inadequate representation of the Nigerian counsel. Proper questions were not put, long timelines were taken for giving in papers, etc. There was complete inadequacy of representation, and the tribunal was not helped very much in the way it was done. And this is something which we face in India also. And therefore, this is one aspect which I'm going to just touch upon in the course of the discussion. The third point which was raised in this was the confidentiality of the arbitral process. in cases where state is an actor, and this was not an investment arbitration, subject to correction, but this was not an investment arbitration. It was a contractual arbitration between a state actor and private parties. Now, when huge, and the award, as was pointed out by my fellow panelists, was 11 billion. I mean, when it came to the final thing, I mean, a major portion of the GDP of Nigeria. So, can such arbitral processes be only confidential, like a normal arbitral process between two parties, or because if there are public aspects which are involved, public monies which are involved, how is the arbitration being conducted, for example? Should this not be open to more greater public scrutiny? Is another question which was raised. And therefore, two fundamental riddles, in my opinion, arise here. One is that how do you reconcile the need for greater intervention by the tribunal and perhaps even regulatory intervention at some level, and I'll explain that, with the so-called spirit of arbitration. The great jurist Fali Nariman used to often quote the honorary president of the International Court of Arbitration, Michel Godet, and who said that, what is the spirit of arbitration, is what he had asked. And he had answered in an email to Mr. Nariman, mutual understanding so as to be able to solve the conflict that has occurred. The aim of arbitration is not to draw from the applicable law a decision against the parties involved, but to clarify, together with the parties, what should be done in a given situation to achieve justice with cooperation. Achieving this process requires all along that all parties, participants, are inspired by the spirit of arbitration. Now, the problem which arises is when this aspect of cooperation becomes a veneer for fraud. Now, an arbitral tribunal may, when a state actor is there, and often it happens in court, but also in the tribunals, that if a state actor is there, there's a bit more leeway given in terms of timelines for compliance with deadlines which have to be put out, etc., etc. That does, what this case shows is that this kind of accommodation which took place and which this tribunal, which was an extremely eminent and experienced tribunal, did do some sort of accommodation to adjust and so that Nigeria could try and present its case properly, can become a fertile ground for fraud. And therefore, there is some kind of interplay between the spirit of arbitration, where does it end and where does fraud begin. Now, it is going to be a case to case. You cannot have bright lines for it. But it is something which I think an arbitral tribunal should be conscious of, that it is not simply a question of cooperation now. There could be possibilities that this kind of delay which is taking place, perhaps even being accepted by the other party, there could be fraud which is there. Be conscious of that and accordingly perhaps modulate the procedure in such a manner that you can have greater intervention, you can have greater discovery, etc. The second aspect which I want to bring out here is that I think here in India, one thing which has been beneficial, and that it was a very controversial section, which was section 29A of the Arbitration and Conciliation Act, which said that you must pronounce your award within 1 year after the pleadings are complete. It was a controversial provision because there was a lot of discussion of whether this is really going to help arbitration or not. And all in all, I think it is a beneficial provision which has been in the long run useful because 2 or 3 things. One is it gets the discretion out of the arbitrator to a great extent, and for the arbitrator to tell the parties, because the culture is to accommodate, as it says, spirit of arbitration. But then to be able to say, I'm sorry, there's a provision here, we have to stick by it. So whatever cooperation it is has to be within certain boundaries. Those boundaries have been set. There is a younger arbitration bar coming up because now arbitrators are not inclined to have arbitrations only in the evening. They want to have it during the day because they say that timelines have to be complied with. And therefore what happens is that there's a younger bar coming in because many of the councils who choose to be in courts can then remain in courts. So I think the section 29A was a beneficial provision, and I think here is something where India can kind of, it's one of the pointers towards the kind of balance one can have towards a somewhat inquisitorial or an interventionist approach in arbitration, balanced with allowing parties to do and go ahead the way they want to. The second part is about the privacy of arbitration, which we are talking about. Now, as far as that is concerned, I think, before privacy, one more point. The point is about public sector representation. It is most of the arbitrations take place, which are taking place, which involve public monies, involve public sectors. And they are extremely lax about arbitrations. they don't take those timelines seriously. And it's not just public sectors, big companies also, promoter-driven, are extremely lax about, they don't take those timelines very seriously. Now here I think is another place where there can be some aid to arbitration by government bringing out guidelines from best practices, which can be put forward before these public sectors to be followed. And I think more importantly, each public sector has a vigilance cell. And I think if officers of a public sector or a state entity are being very relaxed about timelines, not following those best practices guidelines, it should be a point for consideration of vigilance action, consideration of vigilance inquiry. And I think that is something which will put in the discipline, which is absolutely necessary, and aid in the arbitral process. Now coming to the aspect of privacy of arbitration. And here I think the Naresh Mirachkar case, very well known, and which applies equally to arbitration, would be that sunlight is the best disinfectant. And therefore I think it is important some way in which when we talk about arbitral processes where state actors are involved, one will have to think creatively on how these can be open to some kind of accessibility and scrutiny. And in fact, the judgment itself observes that the privacy of arbitration meant that there was no public or press scrutiny of what was going on and what was not being done. When courts are concerned, it is often said that open court principles help keep judges up to the mark, but it also allows scrutiny of the process as a whole. And what lawyers and other professionals are doing, and when a state is involved, what the state is doing is to address a dispute on behalf of its people. An open process allows a chance to public and press to call out what is not right. Now one will have to think creatively, and I think this judgment is a clarion call to think about this seriously. Just to give a flavor of why it is very important, and if we look at the economics of it, and I'll end with that. Today the loss to GDP on account of India's infrastructure project cost overruns, delays, etc., comes to US $80 billion, which has been ascribed to inefficient execution of infrastructure projects. US $50 billions attributable to time and cost overruns. Out of 566 projects in September 2012, 46% were shown to have suffered delays in completion. In 2021, NHAI, one of the biggest litigators in the construction field, was involved in 144 matters before courts and 132 before tribunals. The total claim amounted to 4.37 billion rupees. With these kind of public monies, it is important for scrutiny to come in. And finally, I'd like to end by saying that Justice Knowles had expressed the hope that facts and circumstances of this case may provoke debate and reflection amongst the arbitration community and also amongst state users of arbitration. And I think this is the time for this introspection, and this DAW is an elegant first step. Thank you.
Thanks, Prashanto. Now there's one more speaker left, and none other than Shania. Shania is Deputy Director attached to International Chamber of Commerce. She has good amount of experience, varied experience. So therefore, without much introduction, let me just call upon or request Shania to present her view in the matter.
Hello. Thank you, sir. And it's an honor and privilege to be here among the esteemed panel and amongst the audience. What I would like to discuss today is briefly about the judgment. I know we've discussed facts. I just want to discuss a turning point, which is how discovery process sort of brought to truth the entire backstory of corruption in this case, and sort of like juxtaposition this with another case to show that really, while in the Nigeria case there was actual evidence of fraud, in ordinary commercial disputes, we very rarely find direct evidence. So how do you handle a case like that? And then ultimately, what can you do to sort of have an institutional safeguard and check and balance to rampant corruption, or even in smaller cases of like non-disclosure, what is the process to sort of ensure that this is done in a manner that is fair and increases transparency in proceedings? So beginning with disclosure. So what happened in Nigeria was, like all the panelists before me have discussed, the award was passed against Nigeria. In the liability stage, they found out that one of the witnesses was actually, one of the witnesses had given false statement. In another proceedings, they found out that the evidence that was given on paper was actually incorrect, and that led to a round of disclosure filed in a series of courts, like the UK court, the Cayman court, that came to light, and at the end of the process of disclosure, it came to light that around 40 confidential legal memorandums and proceedings were exchanged that originated from Nigeria, was in the hands of PNID. And that, the Judge Knowles found, was an absolute violation of the party's right to sort of have legal integrity and protection to their own case. And I think that sort of is a tipping point where, Nigeria is lucky. There was hardcore evidence. But in another case, for example, in the Singapore case of CYE versus CYF, a similar argument was made that the absence of disclosure and the absence of disclosure of a particular WhatsApp message that was brought into light in a subsequent proceeding, that this amounted to fraud. And because there's this one WhatsApp message, there will be other similar WhatsApp messages. And because non-disclosure of these messages or these correspondences, which were a part of the ordered disclosure, amounts to a violation of the order of the tribunal that directed them to make this disclosure. So there the court found that this one obscure WhatsApp message does not, in effect, turn the case. So for a disclosure to have a material, or non-disclosure to have a material effect on your proceedings, it has to directly affect the order of the tribunal. So existence of messages that have not directly been disclosed to you, in effect, in that case, was not considered to be a valid ground. And the second point of since you've not disclosed one email, there will be other 100 emails or 100 other messages. There the court said that unless you can show actual evidence of messages or of documents of this nature, an allegation obscurely by saying that the production has not been responsive is not enough. So this is actually, a common struggle that parties face, where, unlike Nigeria, there is very less evidence to prove an allegation of fraud and corruption. Now, from an institutional standpoint, what is needed is that in the entire process, there is a bird's eye view, or there is hand-holding in some instances to ensure that these cracks don't happen, these slip knots don't fall through. So how the ICC sort of steps in here is that all awards that pass from the tribunal are scrutinized under Article 34. So the court sits in the session on a bi-weekly basis or a weekly basis to look at these awards. And for example, in cases where an arbitrator unduly favors a particular party or an important evidence is not considered, these are instances where the secretariat or the court steps in and sort of nudges the tribunal to look at the evidence from a different point of view. This is not to take away from the merits of the case and the duty of the tribunal and the power that they have to decide any case in its own course and based on its evidence, but just an entity that sort of nudges the parties in the right direction and points to the right evidence. And another thing is how if there is an undue delay, or like in the Nigeria case, repeated undue delay by party to disrupt proceedings, on the face of it, if it comes from the arbitrator's side, there is nothing, depending on how great the delay is, if it is something that is absolutely prejudicial, the court has the power to intervene and suo motu replace the arbitrator. And in case it's a party delay that is unduly interrupting the procedure, then what we usually do is that is taken into consideration during the phase when costs of the arbitration are decided. So that is broadly how there is a larger safeguard, a larger viewpoint when it comes to arbitrations. Yeah.
Thanks, Shania. And thanks for bringing out that comparison between Nigeria case and the one which was before the Singapore court. So that brings us to almost the closing part of this particular session. We still have about 15 to 20 minutes. I would like last 10 minutes to be reserved for Q&A session in case there are any interested persons who would like to put the questions to some of our panel members. But before that, see, we have seen the matter from the perspective or from the prism of this Nigerian case. But the matter doesn't rest there. The subject which has been given to us to deliberate upon is riddles of righteousness in arbitration. So the canvas has to be slightly wide. So we have discussed the Nigerian judgment now. I would now call upon every member of this panel to present a view which would be taking cue from this Nigerian, what exactly should be the approach in times to come, and what shall be the appropriate behavior for everyone concerned, including the council. Because what we say is that every model arbitration law will say that the arbitrators must disclose whether they have any interest in the matter or not. Shouldn't it now, hasn't the time come where we now put the very same question to the learned counsel who are going to represent the parties? So therefore, quick bite, 3 to 5 minutes, every one of these learned panel members. Ms. Parnika, your turn.
Thank you, Justice Lalit. So just picking up on that last point about, isn't it for the lawyers to disclose as well? The IBA rules on conflict of interest, which are generally quite widely followed by tribunals, they've come up with a more recent version, I want to say about 2 weeks back. And one thing which was there in the previous and the new ones is obligation on lawyers themselves. So there is a certain provision in that which tells lawyers, it's in one of the examples, used to be in one of the examples, I don't know where it is under the new ones, but it used to be in one of the examples under the lists, where certain kind of relationships or certain kind of, especially monetary relationships, had to be disclosed. And I think it's something Kelvin said as well for counsel. It's very difficult to have a set of rules which govern everyone in the arbitration community, because you have so many different jurisdictions, and every jurisdiction has its own regulatory authority which governs lawyers with slightly different ways in which proceedings are to be conducted. I mean, one very stark example could be between the US and the UK. In the US, when you have a witness, you're allowed to prepare your witness for cross-examination, which is not the case if you're a solicitor with the SRA. You cannot prepare your witness, you cannot coach your witness. So it's very difficult to have a single set of rules for everyone. I think it's more on the ethical sort of guidelines that lawyers need to follow themselves. From the case, another point, which I think this will be my last point because I think everyone, is something Prashanto said about to what extent should arbitrations which involve state or state-owned entities be confidential. And I think it's a very fine line, because the whole point of arbitration, I mean, one of the primary bases for arbitration is that you can have your dispute decided in private. Proceedings are confidential. There's a reason for it. That's a reason why parties choose arbitration. And if one was to start saying that state and state-owned entities' arbitrations should not be private, then arbitration as a process in itself is losing something. And I don't know what the answer is, but I don't think the answer is that all arbitrations that involve state or state-owned entities should be made public.
Thanks, Parnika. Over to you, sir. Mr. Poon.
Thank you, sir. I think the one takeaway that I'm still mulling over as a result of Nigeria is maybe the best way for me to discuss this is to tell you the story behind the thought that's in my head. I was involved in an arbitration involving an African nation, maybe about 10 years ago now. And it concerned an infrastructure project that had been granted by the government to a commercial party. And it was obviously granted on very, very favorable terms to that commercial party. And it was also publicly known that the commercial party was related to someone in the government. And what happened was, before the project was completed, the government changed. And the new government took on the leading role on the platform of reviewing this contract. So shortly after the new government took over, criminal proceedings were started against the promoters of the commercial recipient of this infrastructure project. But at the same time, they started an arbitration against the government for performance, because by that time, the government had committed itself to a position that they will not perform. After all, that's the platform on which they got elected. So when we were in the arbitration, as good counsel, we said, well, we know the allegation is being made, but that there isn't enough information yet at the point in time for us to properly plead a case of fraud or corruption. We have an outline of those of allegation, but we can't develop it. So we ran an argument on contractual arguments. But a point came up as to whether the arbitration should perhaps be paused, given that criminal proceedings were already afoot against the individual in question, and we were expecting the police investigations to take place to uncover more evidence. But I think the balance that was struck eventually was that who knows how long the proceeding is going to last. And so the matter proceeded to arbitration and it led to a certain outcome. So, come back to your question. Would the approach be slightly different in light of Nigeria? Because we all know Nigeria, the case took 5 years before the tribunal. It took an even longer amount of time, or not longer, but a substantial amount of time after the awards to uncover the corruption and the fraud. Who is to say that in my example that I gave, had we gone through the investigations first and we had uncovered something untoward about a transaction, that could have brought the whole proceeding to an end even earlier, even though the decision at outset not to stay was made in the interest of procedural efficiency. And if the court in question says that, look, we recognize the tribunal's duty to uncover fraud, while also recognizing the limits of the tribunal's powers to investigate and to uncover documents that could establish the fraud, should there not be some deference be given to ongoing court proceedings? What was unique, I suppose, in the example that I gave was that the court that was investigating the crime was also the seat court. I can appreciate more difficult questions may arise if the seat of arbitration and the investigation courts are in different jurisdictions, and there are certain concerns about whether the criminal proceedings in those other jurisdictions were not just simply another tactic deployed to derail the arbitration. So I don't have an answer, but I thought I would share the reflection.
That's a very interesting facet which has been brought to the entire discussion. Well, I now request Mr. Prashanto Chandra to have his reflection.
Yes, thank you, Jay. One is, I think the counsels must, as far as the role of the counsel is concerned, not be too eager to please the client. And because many times the counsel himself may not be aware of a fraud brewing up. And so I think it is very important to deal immediately with the senior management at the inception of the arbitration of a public sector or any of these state actors which are there, because this case also dealt with the state actors, so I'm confining there. And I think emphasize the importance of timelines, the whole culture of arbitration which is there, which is often not so well known. And once it percolates down from the senior level, then it becomes much easier and smoother. Otherwise, it can be a harrowing task to deal with arbitration when you're representing a government entity against a really private one. Now, as far as what Parnika raised, I absolutely agree. I mean, it's the whole allure of arbitration has been its confidentiality. But today, I mean, if we look at what went on, it is raising disturbing questions, and we have to look at solutions. And I'm not offering any solutions at the moment. I agree, and that's what the riddle is all about. I mean, these are not answers which can come straight. But it definitely, thing has to be kept in mind. If there are large public resources involved, the issue will get publicity at some stage or the other. And so it is not something which can be avoided. So above a certain level, and political slanging takes place. I mean, the Enron, for example, is an example of that. So, you know, that publicity is going to come. So how are you going to modulate and deal with it? And to what extent should you make the process, should it be open to public? I mean, that's something which needs further thinking and deliberation. But it is not something which is to be taken as a given any longer. That's my point here. Thank you.
Prashanto, what you said is right. Solution, perhaps I think in his professional capacity, you may actually get that solution from. Very well. That was only a lighter kind of, when. Yes, now may I request Ms. Shania to, present her view in the matter.
Thank you, sir. So broadly, I think everyone in the room agrees that in most arbitrations, there is some allegation of fraud, or if not fraud, corruption. It is a trend to plead this. But like Kelvin said, this often derails proceedings. There is a cost component involved. Tribunals cannot actively investigate every allegation. So there should be an agreement on like a common minimum of what are these red flags that across jurisdictions trigger an action from the part of the tribunal and warrant the incurring of such costs. Some of them can be maybe, payment or engaging a third party, and the need for that third party to be engaged arises just prior to the contract, or payments that are excessively disproportionate to the benefit that comes out of a contract. So there is a need for an international consensus, because of the cross-jurisdictional nature of arbitration, to come to an understanding of these are the red flags that need to be investigated, or these are the red flags where a simple allegation of fraud or corruption versus an allegation that needs resources. That is one point. And the other, taking on from what Parnika said, because of cross-jurisdictional parties and what ethics means in each jurisdiction, like US, discovery is extremely extensive, which is not so in the case of arbitration. So parties have a greater chance, or they may just think that, okay, there is a case of clear bias, so let me pursue it in courts, as opposed to trying it in arbitration. So for that purpose also, there is a need to agree on like a common minimum of this is the standard, or although I know that IBA guidelines do exist for even for witnesses, but none of them provide a clear sort of requirement that the parties have to ensure that coaching does not go to the point of active cross-examination, which is absolutely permissible in the US, and you will be you will face action if you don't train your witness how to respond to cross-examination questions. Whereas in a jurisdiction like maybe Singapore and India, which sort of stand in the middle, and we can sort of broadly talk to the witness, but in England, that is also not permissible. So there is a need to understand that even in parties that are operating one UK council, one Indian council, one Singapore council, what each party brings to the table in terms of acceptable standards of practice is vastly different. What each party counts as their responsibility to ensure fair proceedings is also vastly different. So unless there is work that the arbitration community sort of comes towards and builds this common minimum, the solution is case-to-case basis. Rajah.
Thanks, Shania. That was wonderfully put. Now we have come to almost the end of the session. I still have 10 more minutes. So I would request all the learned persons who are present in the gathering to, if you have any queries, any questions to be directed at any member of the panel, please. Yes.
Thank you, sir. Ashish Mitra from GDS Disputes, Paris. Quick question for something Parnika said at the beginning of the discussion. Thank you. I don't know if you could hear me earlier. Yes. Ashish Mitra from GBS Disputes, Paris. Something that Parnika said at the beginning of the discussion was a sort of general skepticism towards whether tribunals can actually go ahead and investigate matters of their own accord. Is there something that international arbitration can perhaps learn from the civil law tradition, where such investigations are perhaps more commonplace? And I'm not just talking about this case, but in all sorts of cases where you may have tribunal-appointed experts, site visits, etc.
Yeah, thank you. I actually practice in a jurisdiction where the actual jurisdiction is civil, which is the UAE, but the offshore courts are common. So this sort of a question is commonly discussed as to what's the interplay between the civil and common law systems as to the role of tribunals and judges. And I think it's a balance, because it's very good to say that can the common law system learn from the civil law system in terms of the inquisitorial nature of a judge. But you have to remember the judges play that role in a civil law system because you don't have witness cross-examination as a rule. You don't have experts being cross-examined. You generally, it's documentary. It's on a documentary basis that the judges make their decision, and that's why they play a more inquisitorial role. But yes, of course, if you have a tribunal which sees evidence being put before it, which shows that there are potential, or there is an allegation of fraud which is supported by evidence, which is not very clear, but it points towards something, the tribunals can ask questions of fact witnesses, but I am not sure to what extent, even in a civil system, can a judge go and start investigating these matters, because there is a sort of a line there between what a party puts forward, what's the role of counsel, what's the role of a judge, what's the role of a tribunal. And I think you need to define those lines to some extent. Otherwise, you'll have everyone start doing each other's sort of roles in a way.
Hello, hi. So, Ganesh Chandru. My question is to Prashanto, Prashanto Sen. We were discussing about confidentiality in arbitration in India. In my view, I think at the moment, confidentiality, though by legislation, we have introduced Section 42A, is a myth, in my view, in India, because even if you go to some of the venues for arbitration, like in Delhi, you have like a board of cost list with the names of the parties, and the cat is the bag. So what, in your view, do you think is really possible to implement this aspect of confidentiality in India, and if so, what do you think we need to do?
I'm sorry, implement confidentiality in what way? Sorry.
You mean confidentiality is just on paper. Okay. What do you think we can do?
Okay, yeah, well, as far as that is concerned, you're right. I mean, as I said, that's why I think where I'm coming from in terms of state actors, it is so porous, which is there. So I think the main thing would be, as you rightly said, that there should not be such kind of publicity on notice boards, etc. You know of which arbitration is taking place where. I mean, that is a very porous thing. So offhand, I mean, I won't be able to give any particular instances of how we can further strengthen that aspect. But I think it is a problem which we are facing right now. And I think you're in a position where you're very much involved in the reforms in some way. And I think that's something what we'll have to look into.
Very well. Nice questions. Yes, ma'am.
My question is to you, sir. I'm Sangeeta Bharti. I'm a counsel practicing in the Supreme Court and High Court. This is regarding Section 29A, which Prashanto mentioned. So we have seen that this is a beneficial provision which was incorporated only to put an end to the arbitration. But what we have seen in practice is that after the 6-month period is over, within 1 year, no arbitration gets over in India. And we are applying to the court for repeated extensions. And these extensions can go from 2 to 4 to 5 extensions. So don't you think we should now try and amend this provision to put a cap of the number of extensions that the court can grant so that we can see an end to the arbitration?
See, again, this is a point which needs to be taken care of by the members of the tribunal themselves. Number one, I have found, whatever limited experience I have on this front, at times, 3 members of the tribunal, they can't agree to a particular time schedule or slots. If they agree, the learned counsel don't agree. So therefore, this period of 1 year doesn't get utilized the way it should be. See, one must actually think backwards. That is, if your deadline is to expire, say, in June, your award must be ready by May. If the award is to be ready by May, by March, the oral submissions must be complete. So therefore, now the clock must be actually sort of, taken in that fashion. But I haven't seen many of these tribunals do that. You are right, this resort to extension of time is taken as if it's a right of the parties. At times, the right of the members of the tribunals as well, correct? So therefore, yes, that's an ethical dilemma of one kind. So it needs to be sorted out. Perhaps I think what the parties can decide is, as one idea could be, if there's a dedicated bar which works purely on arbitration side, Because what happens today is people keep doubling up. They appear in court from 10 to 5, and then they would like to have the arbitration sort of, proceedings to be taken at a time slot which is convenient to them. So therefore, there must be a dedicated bar. There must be a tribunal which must also devote time. And when you give your declaration, you have to give a declaration disclosure that you will be able to finish the arbitration well in time. So these are, of course, yes, the ideal situations, but perhaps I think we need to gear up in that particular direction.
Thank you, sir. Thank you.
Anybody else?
Good afternoon, sir. I am Atif Mathur. I am a counsel practicing in Delhi High Court, Supreme Court. Just a small question or maybe suggestion, and who better than you can possibly guide us on that. What we feel, which is something related to the topic also today, after 1996 Act, we are almost at the 30 years we are ending here. And we often feel that the law related to arbitration is not yet settled so far. I am not undermining the power of the courts to pass the judgments and review the judgments and refer it to the larger bench. But often it is felt that after the 30 years, the basic issues, like we have recently seen a case where the power of 34 or 37 courts are being referred to now larger bench, power of 29A, power under 11, they are all being discussed even after 30 years and the law is not settled. Are we not giving tools in the hands of our own fraternity to argue beyond the point which is being settled, and then it get resettled and unsettled again and again? And is it not disturbing the entire trend if we have no certainty in the legal precedents? Possibly.
Whatever had earlier been laid down. Otherwise, we would be living in a very straitjacketed idea that whatever has been there, and we must decide purely on the basis of that. The evolution of law always takes place. So therefore, whatever may have been, this is that famous case, Motor General and Finance, that whatever was constitutionally valid may after a period may become invalid. So therefore, we live in that particular with this kind of jurisprudence which keeps ever evolving. So therefore, just last week, there was a decision which upset P.V. Narasimha Rao case. Correct? 7 judges. See, it happens. That's the evolution process. You can't then blame the system for that. You are equally part of that system. Perhaps I think, you should, as and when the occasion comes, place all the submissions before the court, and without leaving any doubt to be sort of lingering for the future generations. Okay? Thank you. So we have come to the end of this session. It was a very engrossing, very enjoying session. I have enjoyed it. And this subject is very beautiful, righteousness in arbitration. This is what I said in the opening. Apart from impartiality, independence of the arbitral tribunal or the members of that tribunal, today we have now come to accept that integrity of the process is also something which is the hallmark of what is called good arbitration and good arbitral proceeding. Thank you for being part of this discussion. Thank you so much. We enjoyed it. I hope you also enjoyed it as much as we all did. Thank you so much.
Thank you. Thank each and every panelist for gracing us with their presence today. Thank you. I'm quite sure that was an ethically righteous session as well. We'll take a short 10 minutes break, please.